Thank you. You may be seated. Robert Hriniak versus Fred Malden et al. And Bruno Appliance and Furniture Inc. versus Robert Hriniak. Saret E. Batner, Brandon Kane, and Moya J. Graham for the appellant. Javad Heydary, Jeffrey D. Landman, David K. Alderson, Michelle Jackson, and Jonathan A. Odumeru for the appellants in the second action. And I think I've got that right. Thank you. Mahalia Wilson and Christopher P. Thompson for the intervener, Attorney General of Canada. Paul R. Sweeney and David Stearns for the intervener, Canadian Bar Association. David W. Scott, Patricia D.S. Jackson, and Crawford Smith for the intervener, the Advocate Society. Alan Rubin and Ronald P. Bohm for the intervener, Ontario Trial Lawyers Association. Ms. Batner?
Good morning. There are three principal issues in these appeals. 1, when is a trial required? 2, is a trial required here? And 3, if so, is it appropriate to suspend application of this law and engage in prospective overruling? Fair adjudication of private disputes is a central goal in the Canadian justice system. To succeed, the system must both be just, in that it must provide an adequate procedure to permit confidence in the conclusions reached, and it must be accessible. This court must decide when the interest of justice requires a trial and when summary judgment motions will provide a fair process for the safe determination of disputes. I respectfully submit that whichever factors this honourable court determines are the appropriate considerations for when the interest of justice requires a trial, the Malden and Bruno actions embody them. I intend in my time to follow the 2-page submission at tab 1 of my condensed brief. The first issue I want to address is, when is a trial required? Under the old Ontario rules, trial was the default procedure for all dispute resolution. The result was decreased access to justice as trials grew too costly and the delay in getting to trial grew too long. As a result, wide-sweeping amendments were made to the Ontario Rules of Civil Procedure effective January 2010. The amendments introduced an overall imperative of proportionality, simplified procedures for cases up to $100,000, reduced discovery time in all cases, case management, as well as other changes. New Rule 20, the summary judgment rule, was one part of the overall attempt through the rules to improve access to justice and imbue the system with proportionality. The role of summary judgment within the overall system was expanded. Under amended Rule 20, summary judgment is no longer the exceptional procedure for dispute resolution. It is available in all cases unless it is established that a trial is required. At tab 2 of the condensed brief is the language of the rule. If you turn to the first page at tab 2, at the bottom, we see Rule 20.04 sub 2. The rule says, the court shall grant summary judgment if, over the page, A, the court is satisfied that there are no genuine issues requiring a trial with respect to a claim or defense. And then under the heading Powers 2.1, in determining under Clause 2A whether there is a genuine issue requiring a trial, the court shall consider the evidence submitted by the parties and, if the determination is being made by a judge, the judge may exercise any of the following powers for the purpose, unless it is in the interest of justice for such powers to be exercised only at a trial. And then we see the traditional fact-finding powers, which under the old rules were reserved to trial judges. 1, weighing the evidence. 2, evaluating the credibility of a deponent. 3, drawing any reasonable inference from the evidence. New Rule 20, under New Rule 20, summary judgment is no longer exceptional. The requirement of a trial is the only limitation on when summary judgment is available. It is grounded in 2 places in Rule 20. 1, to use the expanded powers, and 2, to ascertain through their use if a trial is genuinely required. As a result of the amendments to Rule 20, many more cases can now be resolved on summary judgment, but clearly not all. The key question is, when is a trial required to achieve a just and fair result? The Court of Appeal convened a 5-judge panel comprised of 4 experienced civil litigators and one of Canada's leading academics to consider this question in the context of 5 varied appeals and to provide the guidance that had been requested of it by the bench and the bar. The Court of Appeal correctly directed itself to the language of Rule 20, which embodies the values underlying the recommendations in the Osborne report on which amendments were based, and asked itself, what are the unique properties of a trial that make a trial the process required in some circumstances for there to be fairness? In Housen, this honourable court wrote about the unique properties of a trial. The Housen principles of trial attributes can be distilled into 4 points. 1, the judge participates in the dynamics of a trial and asks questions when in doubt. 2, the trial judge sees the witnesses testify and hears the evidence in the words of the witnesses, as opposed to the words their lawyers drafted for them in affidavits. 3, the judge follows the trial narrative and monitors the cut and thrust of the adversaries. And 4, the trial judge therefore enjoys a privileged position as a participant in the unfolding evidence at trial, particularly on issues of credibility, where the trial judge's advantage is, in the words of this court in Housen, overwhelming. Against that backdrop, the full appreciation test developed by the Court of Appeal asks, can the full appreciation of the evidence and the issues that is required to make dispositive findings be achieved by way of summary judgment, or can this full appreciation only be achieved at trial? Put another way, are the Housen attributes of a trial required in a particular case for a fair process? Or can fact-finding powers safely be used on summary judgment absent the Housen trial attributes? If the fact-finding powers cannot safely be used on summary judgment, the case cannot be fairly and justly decided in that summary forum. If they can, then even though the Housen trial attributes might add procedural fairness, there can be sufficient confidence in just conclusions in the summary procedure, and thus the motions judge can fairly use the fact-finding powers.
Don't we have a bit of a problem here as I listen to you frame the argument? We're dealing with words that are so subjective, just, fair, the purpose of a trial, I mean, not to be disrespectful, but the romance of a trial. The whole point of Rule 20 is to say, yes, that's very important, but there's another way to be just, fair, etc., and that is to avoid a trial. So I guess the words of justice and fairness are exactly what both sides invoke them. Both sides, I think, are right in their own way. So I'm just not sure that those adjectives are necessarily helpful in helping us figure out what we should be thinking about in the new Rule 20.
Thank you, Justice. We can take our guidance as a starting point from the rule. So the legislature clearly contemplated that the category of cases that require a trial in order for fact-finding to be fairly done is populated with something. There are some cases which require a trial in the interest of justice, and only those that require a trial are to be sent to trial. So we know there's something in that. And so what the Court of Appeal said is, okay, well, what? What is it that's so special about a trial that in some cases it's required? And they look to Hausen. But then the Court of Appeal, recognizing in my submission this very problem, said, let us give you some guidance. Let us help you, in response to your request, understand when the interests of justice are likely to require a trial, and in all other cases we can deal with these matters on a summary judgment motion. So the Court of Appeal provided hallmarks of cases that require a trial. And they said those cases are cases where multiple findings of fact must be drawn on the basis of, 1, conflicting evidence emanating from many witnesses, 2, found in a voluminous record, and 3, where contests of credibility lie at the heart of the dispute.
Can I just take you back to the questions that Justice Abella was asking, and your description of a trial being required when it's fair. And I'm just asking, where do the other values that are found in what is it, Rule 1.041 and 1.1, the values of the least expensive, the most expeditious, proportional to the complexity and importance of the issues in question and the amount. Where do those values fit into that analysis of what's in the interest of justice?
So I would say, Justice Kagan, in 2 ways. 1, what the Court of Appeal was driving at in my submission is, if I can put it this way, the lowest common denominator. When is the point below which there is something about the character of the evidence and issues in the case that we no longer have confidence that if it's done without those Hausen attributes, we're going to have sufficient confidence in a just outcome, in a right conclusion? So they said, we have to consider what about the character of the nature and the issues engages this concept of needing a trial. And then they identified those cases where it's likely to be the fact. And so whether the case is worth $2 million or whether the case is worth $200,000, if because of something inherent in the evidence and issues in the case, it can't fairly be decided by a judge having a few hours with lawyers and then going and reading the words largely of lawyers in their chambers, then justice can never be done, because out of a fair process comes a just outcome. But the Court of Appeal expressly recognized in its decision that these principles of proportionality, expense, and delay. Specifically, what they said is, cases which bear all the hallmarks are likely to be complex and therefore are likely to be ones in which summary disposition is unlikely to be a proportionate response. Pursuant to the definition of proportionality in 102, complexity is one of the considerations. 1.04, Rule 1.04. The Court of Appeal also expressly recognized in its decision, for instance, when dealing with the Parker case, which was one of the 5 cases in which summary judgment motion had been brought in a simplified procedure action, that motions judges may also need to consider whether efficiency is promoted by proceeding by summary judgment.
I think part of the issue, with respect, it would be very hard, I think, to find somebody who has lost a trial who would tell you that they are really comforted by the fact that they'd had this long, expensive, overdrawn trial. And I think nowadays we have to concede that there are very few cases that don't have the hallmarks of complexity of the issue, voluminous record, and testing credibility. So I'm really not sure it's helpful. I know you're working with the words require a trial. But what about looking at it another way, and that is the resolution of a civil dispute between parties, rather than is a trial a good thing or a bad thing, and looking at whether this offers another way of promoting dispute resolution that is not the traditional way we had thought we were the only way to resolve disputes.
Let me try it this way. What the Court of Appeals said is, here are the hallmarks of cases in which a full appreciation is unlikely to be available without the Hazen trial attributes. But let me tell you what happens if you try and bring those cases to summary judgment motion. 3 things happen. 1, those motions, so motions where you have multiple parties and lots of affidavits and lots of cross-examinations, etc., tend to be long and costly because of those features. So you've shifted now from a long and costly trial to a long and costly motion. In these cases, never mind the preparation time, there were 3 weeks of cross-examination and 4 days of argument. So the concept that a trial would have been less costly or taken less court time does not bear out when you have what the Court of Appeals hallmark.
That's a non sequitur, because trials could be, we have to know what's on the other side. How long would the trial have taken? Just because a motion takes a long time doesn't mean that it's not going to be more economical than trial. The trial could take 3 years. I mean,
it's driven at this concept, which the Court of Appeal picks up in paragraphs 57 and 58 of its decision. If a summary judgment motion is brought by a plaintiff, then if it's brought in respect of one of the issues in the case, which is dispositive, for instance, a limitation period or some provision in a contract, then it can provide a real narrowing of the issues. So if you have issues of limitation period, liability, causation, and damages, but it all turns on the limitation period, then if you sort that out on a summary judgment motion, you can save 10 weeks of trial because none of those other things matter. So even though the case is complex and contentious, that complexity and that contention doesn't go to the heart of the dispositive issue. Similarly, if a defendant brings a motion for summary judgment, then all a defendant must do is really poke a hole strongly in one required element of a case, and again, you can see a narrowing of the issue. It's of no moment if the plaintiff can prove everything else. The defendant can concede that for the purposes of the motion and target one issue in the case. But in a case where the plaintiff moves on all of the issues in the action for a summary judgment instead of a trial, the procedures in a real way start to conflate. And what the Court of Appeal says at paragraphs 57 and 58 of its decision is if the affidavits and cross-examinations simply anticipate and replicate what would happen at a trial in any event, then you have to question whether you're having any efficiency by proceeding in this summary fashion.
But if I look at, for example, Article Section 2005 of the rules, do we really have in the rules such a dichotomy between the trial proper and summary judgments? If you look at 2005, even if you get into the paradigm of the trial, there are there are many powers that can be exercised by the court really to manage the trial. So the difference between a complete trial and a summary trial is not all that clear. It seems to point actually in the rules that the rules give the power to the court to decide to craft the kind of trial that will be appropriate for the matter at stake.
Absolutely. So there is no doubt that the rules, not only in Rule 20.05, but elsewhere, give the court broad speaking powers, and this has recently been the subject of jurisdiction in Ontario, to manage cases. And in my submission, what the Court of Appeal was trying to do was say this: put the right cases in the right places if you really want to get rid of the justice delayed problem. Because if you move all cases which were previously in line for trial dates and now move them to be in line for summary judgment motion dates, all you end up is with moving the problem of delayed access to justice, not solving it. So in my submission, what the Court of Appeal was trying to say was really to litigants and their lawyers and also to the bench to say, look at your case. Look at your case and manage it in an appropriate way. If it looks like this and has these hallmarks, you are not likely to be able to manage it on a summary judgment motion. You are likely to run into genuine issues requiring a trial or other problems. So move quickly to trial. Seek case management. Meet with the other side. Narrow the issues. And if your case looks like this, by contrast, more limited, there's one issue that is determinative, etc., go to summary judgment because you can resolve the case without the need to deal with the trial system. But if we don't have a concept of what cases are likely to be useful in what forum, then every case effectively goes to summary judgment and when
or to trial. Every case, because I mean, here's the other thing that I think. It's partly the way we look at what constitutes a legitimate Rule 20 motion now. All we've done is taken the trappings of a usual full-blown, full-panoplied, arsenal trial and put it into a summary judgment, rather than looking at this as a unique kind of tool, as the Advocate Society says. Something that really does require a summary approach to credibility, to the assessing of the evidence, rather than this voluminous mini trial which takes months and months and months. So it's true it's shorter probably than a trial, but isn't this partly because of the way we look at what constitutes a Rule 20 motion?
Right. Fundamentally, my submission in defense of what the Court of Appeal said, which is not my position, but my position in defense of what the Court of Appeal said is this. The rule, and this is where they start, clearly contemplates, so the legislature has spoken and clearly contemplates that while they were setting about trying to come up with something expanded and new and cheaper and faster and more proportionate in all ways, that we recognize in our system, the legislature recognizes, that there still are some cases where the expanded fact-finding powers can only be used at a trial. And so we must grapple with the question, when is that? To give that language some meaning, we must ask ourselves, when? When is it only in the interest of justice to use the expanded fact-finding powers at a trial? And so to give that some meaning, we have to answer that question. And in my submission, what the Court of Appeal did make sense to do. They looked at what a trial offers that is different. And it really is this business of fully appreciating the evidence in the sense of being present for the whole thing, seeing the cross-examinations and participating, which gives a higher degree of involvement and therefore a lower degree of likelihood that you will overlook evidence. So, is there another approach? There may well be another approach. Others here have suggested that in asking, do the interests of justice require a trial, we should look at the value at issue in the case, we should look at how long the motion would take, we should look at how long a trial might take. Those are all interesting factors. They aren't, and in my submission, if that's where this Court ends up, those are all reasonable suggestions put forth. They're certainly the ones that have been looked to in British Columbia, although it's important to note that that's in the context of summary trials, which was expressly rejected by the legislature in Ontario.
Can I ask you this, though? The concern that's been raised is when a summary motion trial fails, you've wasted time and money. And I think the answer that's been given in response to that is that there's a trial management rule under 2005, and that under that trial management rule, the judge who dismisses the motion can fashion a summary trial. They can limit the number of witnesses, they can do affidavits, they can put time limits, they can fashion a summary trial rule. So my question to you is this: is there any reason why the judge who is seized of the summary judgment motion, who dismisses the motion, and who has the tools of being able to fashion a summary trial in that case, is there any reason why that judge can't remain as the trial judge? Because one of the concerns about the trial management rule is that you've taken away options from the trial judge who's going to actually hear the evidence. And so that's my question to you.
So
Can they
my submission is no.
Why not?
In my submission, if the trial judge says it's not in the interest of justice for me to exercise these powers on a motion for summary judgment because there's something about a trial that I need, then the motions judge does have powers under 20.05 to fashion remedies. Whether the judge can seize him or herself of the matter is actually probably more a practical concern. This actually came up before the Court of Appeal, and I can't remember now, but I believe it was Justice Rouleau made the point that that is not how we assign trial dates and motion dates and how we deal with scheduling. So there's a practical restriction. But in principle, no. But let me say this, If a motion for summary judgment fails in whole or in part or doesn't dispositively resolve of the case, no matter what you do after that, it's a salvage mission. So you may be able to say,
I'm going to put in one more factor into the mix. There's the rule that allows you to go for directions. So suppose the summary judgment motion judge is the same judge to whom you go early on for directions, who can direct what the record should look like in the summary judgment motion, and so that it doesn't become a bigger record that's available under discoveries, for example. So you've got a summary motions judge who is dealing with the motion for directions up front, who's helping the parties to determine what the appropriate evidence is for the summary judgment motion. Here's the summary judgment motion, tries to resolve it, but if they feel they can't, then has the trial management tools available to fashion a summary trial that's appropriate and proportional. Why doesn't that make sense and create better access to justice?
it does. In my submission,
Is there any reason why you can think of that it wouldn't make sense?
No. And other than the practical concerns of scheduling and the issues of who assigns trial dates and how judges work, but other than that, it makes sense to trial manage or to case manage actions to their just, most expeditious, least expensive resolution. None of that changes the fact that there will be cases in which it is not in the interest of justice for the traditional fact-finding powers enunciated in the rule to be exercised other than with the comforts of the house and trial attributes. And so, Justice Karakatsanis, when you made the point, what about a motion for directions, it's not only to fashion what should and shouldn't be in the record. So, in other words, if you have a limitation dispute, I don't need to hear from you on causation or liability. Let's get to the heart of it. But it also is to consider whether the character of the issues and the evidence are such that it won't be in the interest of justice for them to be determined on a motion for summary judgment. For example, if you have two people telling two different stories and no records one way or another, so you just have he said and you have she said, and that's what's in the affidavits, that might be exactly the kind of case where you say, I mean, maybe what you say is we need a one-day trial and we're going to, sort it out that way, which is fine. But that might be exactly the kind of case, and in my submission it is, where absent a documentary record to allow you to go one way or another, which would give you comfort that the attributes of a trial won't likely impact on the outcome, you're not in a position to justly arrive at a result. There has to be something to that, and in my submission it has to focus on what does a trial offer, what are the attributes of a trial that just don't exist on a motion.
But in your simple example, why isn't that an example of the summary judgment judge ordering oral evidence on that one bit of conflicting evidence between the two parties?
If it's a narrow issue like that, then my submission is that is what would happen. If there is one contested issue of credibility, then you would be in the Court of Appeals example of a case which is amenable, and the summary judgment motions judge would say, I need the expanded powers to resolve this, but I'm confident and comfortable that the interests of justice don't require that they be used only in a trial, because I'm going to be able to have recourse to the next section of the rule, which I didn't read, which allows me to ask for some oral evidence. So absolutely, these are all ways in which these cases should be managed. None of them reduce to zero that there will be some cases where the attributes of a trial are required for fairness. And when you have many factually contentious issues between many affiants where credibility is at the heart of the dispute and you have no reliable documentary record, the reality is it is no longer efficient, proportional, it's no longer quicker to have a day or so with counsel and then have the judge go off and spend probably weeks, that's how long it takes to review that many volumes, and try and figure it out on their own. And that
He's
is
not just, but aren't we just maybe not being a little realistic? Maybe there are 28 volumes of transcript and maybe there are 18 witnesses and things like that. But in argument on the summary judgment motion, the lawyers are directing the judge as to what's relevant in those 28 volumes. And so, counsel has a responsibility to point the judge in the right direction, or at least in their view, what the right direction is. And so maybe it's overblown to say, oh, well, we've got 28 volumes and so forth.
So 2 points in response, Justice Rothstein. One, of course it's the obligation of counsel to do that, but it is very hard when there are multiple issues and lots of different people taking positions on them, and the evidence goes in lots of different directions on key issues, to assimilate it. You've spent probably weeks, months, or years with the case. The judge comes at it anew, maybe having reviewed the record once, and it's hard to take it in. And that's part of what this Court talked about in Housen, being able to live through the process a little bit and take it in. And second of all, again, it's whether or not you give any credence to what this Court said in Housen about the unique position of a trial judge to hear and see the witnesses and participate in that way.
Well, I think I have some difficulty with seeing this black-white. Housen is a trial. The summary procedure will have none of those attributes. If you look at what they're talking about, paragraph 50, total familiarity with the evidence, I would expect that a judge on a summary motion would have total familiarity with the evidence required. It might not be everything. He might not hear from 100 witnesses, but people would direct this judge to what is essential. And so the judge would become familiar. We're not talking second-rate justice here. We're talking more expeditious justice. We're talking about getting to the point instead of going through the motions. Extensive exposure to the evidence. I think that a summary judgment, judge should have extensive exposure to the evidence that matters. That could be done, however, in a summary form. Familiarity with the case of a whole. Of course the judge has to. Those are things that I would expect would happen in a summary proceeding. So this dichotomy of sort of saying, here's Housen in a trial and here's something much less seems to me to get you off on the wrong foot. I don't see that dichotomy. I would hope that any summary trial the judge is going to be familiar with all of the relevant evidence. But I thought when I read Rule 20 that and the amendments was that what the legislature was saying is, let's not get hung up on the formalities and trappings of a trial. Let's see what is required to decide this particular dispute efficaciously. Our judges have the ability to do this. They can get to the point. Our lawyers can get to the point. So let's treat each case. But we are not sacrificing, just to come back to my main point, a full appreciation of the relevant evidence. We're not sacrificing any of those Housen things, it seems to me. So this is my problem with the way the Court of Appeal reasoned.
Okay. So it's a long question, but
I know. Well, it's a comment.
Let me say in summary this. If we don't start from the proposition that some cases require a trial, which in my submission we must start from that proposition because the legislature expressly said so, then it's tautological. If no cases require a trial, then all cases can be decided on summary.
Well, that's not what I'm suggesting at all. I'm sorry, but if that's your comment, it's not really helping me, because I'm not suggesting that there aren't some cases which are so credibility driven that our normal trial process will not work well.
And that is all I am submitting, that whatever this Court puts around exactly what you, Chief Justice, just said, that is what we have to figure out. What are those cases which, to use your words, are so credibility decision that this summary process won't work well? That is the question. The Court of Appeal tried to address it one way.
Well, maybe we can move on to that. I think myself at this point, and you can enlighten me, but it's a very complex question, and it's case-specific, and it's one of those things that's going to be very hard to put into a category system. Or to deal with simply by adjectives like complex. And even the adjective full appreciation, you have to ask yourself, deconstruct it, what does it mean? Surely words like required in the rule, requiring a trial, suggest a sufficient appreciation to get to the point.
I agree. The in my submission, the nomenclature was intended to fall down to that threshold, but if it was poor, then my submission, it was poor. I believe the Court of Appeal was attempting to get at what is that level of appreciation that you can only require it as a trial and leave everything else to summary judgment. But that is the question. The Court of Appeal even says it's a case-by-case determination. They say that too. But what they said, as this Court said in Van Breda, is sometimes it's helpful to have some guidelines, some characteristics that help us understand when we're likely to be able to use this process. But let me go from the broad to the specific and talk, if I can, about my second issue, which is a trial required here? If the interest of justice, in my submission, if the interest of justice does not require a trial in the Bruno and Malden cases, it is hard to imagine a case in which it would. Indeed, the Court of Appeal went so far as to find at paragraph 153 of its reasons, quote, undoubtedly, if the motions judge had had the benefit of these reasons, he would have sent both actions to trial. So I ask this Court to consider these 9 factors.
Just before we get to your 9 factors, could we get to paragraph 154 of the Court of Appeal's reasons?
Absolutely. So in paragraph 154 of the Court of Appeal's reasons, they say we have to decide what we're going to do. One obvious approach is to set aside summary judgments on the simple ground that cases of this nature should not be resolved summarily. And then they say, however, we're not going to do this because, and they give 2 reasons. One, the decision was reached after careful scrutiny of an extensive record. And so, again, this Court recently said in the Merck case that careful scrutiny of the record is in every case. And 2, the law was unsettled. And that's my argument on prospective ruling.
Well, just a moment. I was going to ask you a question about this paragraph rather than have you read it to me. If we could take you to the end of the paragraph, the very last sentence. In the light of these particular circumstances, we are prepared to look beyond the characteristics of these actions that would otherwise preclude summary judgment to determine if the motion judge was nonetheless correct in granting partial summary judgment. And then if you look over at the page, to paragraph 156, having reviewed the extensive record, we conclude that it firmly supports the motions judge's determination that Hreniak committed the tort of civil fraud. His defense to this action simply has no credibility. So it seems to me that whatever is prompting the Court of Appeal to say this case is not suitable for summary judgment, it is not related to the safety and justice of the outcome.
And in my submission,
do you agree with that?
No. Well, I agree that's where they end up.
Right. So that their categories are not designed primarily to identify cases where summary judgment will not produce correct results. There it's concerned with other factors.
In my submission, the Court of Appeal is wrong about that, and what it means to say that the house and trial attributes are required in this case because of, amongst other things, those 9 factors, is to say that if you try and wade through this evidence and these issues on a paper record, you will fail to appreciate evidence and you will run into problems. And so let me give you, if you'll allow, an example. And it's in the facts of this case, which is not a policy argument, but if you'll just bear with me for a moment. The Court of Appeal, the finding the Court of Appeal made in the Bruno action concerning inducements, i.e. in Bruno the Court of Appeal said, it's not clear whether Mr. Hreniak made any statement that induced Bruno to invest with him. The motions judge did not address this important element of a cause of action in civil fraud. That applies equally in Malden. So they didn't find that, they didn't glean on that, but it applies equally in Malden. The motions judge made no reference to inducement, what actually induced the Malden plaintiffs, and no finding on inducement. At paragraph 170, the Court of Appeal said, fraud requires a false statement knowingly made that induces a victim to act to the victim's detriment. That's true in Malden. At paragraph 172, the Court of Appeal says, we do not know what statements persuaded Bruno to invest. Maybe something Peebles said, maybe something Cranston said. For these reasons, whether Mr. Hreniak, through Peebles, made a false statement that induced Bruno to invest is a genuine issue requiring a trial. Can't figure it out on this record. That is the same in Malden. And so, if you contrast that by what the Court of Appeal did in Malden, in Malden, in one sentence, the Court of Appeal said at paragraph 158, Unquestionably, the Malden Group was induced to invest because of what Mr. Herniak said to Malden at the meeting at Castlesbrock on June 19, 2001. There was no mention by the Court of Appeal of the motions judge's error in failing to address this issue in the Malden case. There was no finding by the trial judge. So the Court of Appeal made that factual finding on its own. It went back to the chambers. It reviewed the 28 volumes plus the transcripts. It tried to pull out what induced the Malden plaintiffs, and it made that filing on its own. And when you read the decision, in my submission, what happened is exactly what it warned would happen when the housing attributes are required. It overlooked material evidence because of this. The motions judge held at paragraph.
I take your point that you, in your submission, the Court of Appeal was wrong in the conclusion it reached. That's not really what I'm asking you. Could you just listen to my question, please? The Court of Appeal says two things in the paragraphs we've just reviewed. One, this case is not suitable for summary judgment. Two, the result of giving summary judgment is correct and just. What does that tell us about the purpose of these categories in the test?
It tells us in my submission that the Court of Appeal erred when it said it could set aside the characteristics which otherwise preclude summary judgment. Because what it means to say the characteristics preclude summary judgment is to say there's something about the quality, the character of the issue and the evidence that makes sorting this out on a paper record without the housing trial attributes unfair. And just to finish the point, in the motions judge found, as a finding of fact, when he spent 4 days listening to counsel, that Mr. Cranston played a significant role persuading the Malden Group to invest. But very importantly, there's a letter of interest signed by the Malden Group before the Malden Group ever meets Mr. Herniak, before the June 19 meeting, and it's at page 157 of the Respondent's Volume 1 of their record, where the Malden Group plaintiffs say that it's executed by Mr. Malden, and it says, it confirms his intention to immediately participate in the Tropos investment in the amount of $1 million. So before he ever has that meeting, he's signed a document confirming his intention to participate in the Tropos investment in the amount of $1 million. At the meeting, no one finds as a fact what was actually said. Mr. Malden's evidence is that why he wanted the meeting and what he took from the meeting was that Castles was behind this transaction, and that's what comforted him. So nowhere in the evidence, and certainly not in the affidavits of Mr. Malden, is anybody saying that what Mr. Herniak said induced him to invest. In my submission, all of these relevant facts that predate that meeting and all of this issue of inducement, the reason the Court of Appeal overlooked that and came to a conclusion which isn't borne out on any fair reading of the record is because it listened to counsel for half a day, largely on legal issues, and then was left to its own devices to go back and figure it all out in its chambers. If the Court had instead been in a trial or even a mini-trial and seen Mr. Malden in the witness box and seen him cross-examined on the letter of intent and heard his evidence of why he committed $1 million before ever meeting Mr. Herniak and only wanted to go to Castles to get comfort of Castles and Peebles' involvement, then that, in my submission, is exactly what the trial attributes say would make a difference. It would matter because it wouldn't be overlooked or it would be less likely to be overlooked in the outcome.
Ms. Batten, I hope you'll forgive me if I tell you I feel like I'm in a time warp and that I'm listening to the arguments in a goonie all over again, and that we are here trying to decide almost as if there hadn't been an amendment to Rule 20. Arguments about whether a motions judge can decide facts, credibility, all of these issues was what found its way into the Ungaminaguni jurisprudence, and that's why Justice Osborne came out with his report, and that's why they changed it. And yet here we are discussing whether this is the best place to make findings of fact. We had that discussion, and it's over, and now we're in new territory. We have to figure out what that map looks like.
Agree.
Not the old map of you can't really make these findings of fact or credibility in a motion. The legislature said, yes, you should, in certain cases.
Right.
So
That begs the question. And so I agree with your point, Justice Abella, that this is a new world order. The legislature, the Osborne report itself said, use these expanded powers to resolve non-complex cases when it's not in the interest of justice to do it at a trial because it's safe to do it on a motion. That's language that comes out of the Osborne report, quoted in the Court of Appeals decision at paragraphs 22 to 27. So this concept that even in the New World Order, where way more cases can be done on summary judgment, there's still something about some cases that require a trial, comes from Osborne and the legislature.
Where does the role of the merits come in? I know that that's a bit circular. You can't get to the merits unless you know what the facts are and all that stuff. Where does the concept from Gordon Capital, the good hard look, come into this discussion?
So the rule says the motions judge shall consider the evidence of the parties. And in my submission, what the motions judge does is say, what are the issues I need to decide in this case? And then they say, what is the evidence relating to those issues? And then they step back and say, is there anything about the quality of the character or the character of the issues and evidence that makes them unsafe for resolution without the housing trial attributes?
What does unsafe mean?
It means that you cannot, because of what you see when you look at it, it
Like
means
findings, conflicting facts and conflicting credibility, all of the old stuff. The traditional.
no, because you can resolve conflicting credibility. Many of the old summary judgment motions were one-issue motions, where there really were. It was an informed consent case and there's two parties, or it's a contract case and there's a threshold issue in the contract. There are lots and lots of cases where there is an issue which governs. Precious metal was a case that came before the Court of Appeal after this case, where they said, in spite of the voluminous record and in spite of the multiple credibility issues in this case, we can have a full appreciation, because when you really look at what needs to be determined to resolve this motion, it's this issue. And yes, there's a credibility contest on this issue, but it's only between these two people. And when I look at the panoply of documentary evidence surrounding this issue, this is something that I feel comfortable doing on a record, on a paper record. It's not going to get better at trial because I have lots of documents, which speak for themselves, to help me out. And so in my submission, that's the same Court of Appeal making that decision. This was intended to direct cases to the place they were most likely to end up being justly, expeditiously, and least cost-effectively resolved. But the bottom line still is, in cases that have the hallmarks, maybe you can cut. Maybe when you look at what is really at issue, that's not an issue. That's not a problem. But in cases where you have everything, the whole trial is there, everything's in the mix, it makes it, as Chief Justice McLaughlin say, that is maybe the small group of cases where you can't be comfortable. We don't have. The legislature rejected summary trial. They did intend to say, if we can do it this way, we should, but there are still some cases where we can't. And in this case, in my submission, it was such a case, because the motion was brought before examinations for discovery, number one, which matters because, as the Court of Appeal said, there's a caveat to the best foot forward principle when you're early in the action, which doesn't mean it's never appropriate, but if you're moving on all of the things in the case, it might be. Two, the motion record was extremely voluminous, not categorical, but relevant. There were 18 witnesses, 3 weeks of cross-examinations, 4 days of argument. Different theories of liability were advanced against and between 3 defendants. Numerous findings of fact were required to decide the motions. Credibility was at the heart of the disputes. The major witnesses, even amongst the plaintiffs, conflicted on key issues, like what was said at the meeting. The Court of Appeal doesn't mention this in their decision, but it wasn't just Mr. Malden at the meeting. Mr. Myers was there, too. And the motions judge found their evidence conflicted. The motions judge found at paragraph 17 that even their evidence conflicted as to what happened at that meeting. The Court of Appeal noted there was a near absence of a reliable documentary record. The motions judge called it a jumbled mess. Here, a trial will take place in any event against Mr. Peebles, Cassels-Brock, and the cross-claims, and as the Court of Appeal noted, will inevitably canvass the same issues. All the same parties will have to testify. All of the same issues will arise. And the credibility of Mr. Herniak was really bound up in the credibility of Mr. Peebles. In fact, the whole case came down to the motions judge saying, I don't believe Mr. Herniak, because when I look at this, it doesn't ring true. But then he said, but Mr. Peebles, the managing partner or the former managing partner of Cassels-Brock, who was intimately involved, might have not noticed that it didn't ring true. He could have believed in the veracity of everything that was going on and only have been a dupe. But that doesn't make sense. If it was so obvious that we can just dispose of it with a paper record, that it was so obvious, then how can we leave for trial whether or not Mr. Peebles was in on it when the finding of fact is he was intimately involved at every stage? And in this case, millions of dollars were at stake. So we don't have the proportionality argument that there isn't a lot at issue and we need to, in terms of the amount of the case. And all of this was against the backdrop of fraud, the most serious civil allegation. And in my submission, proportionality includes considering the importance of the issues to the parties. And in fraud, the importance of the issues to the defendant, who also is entitled to access to justice, is at its highest. The allegations are stigmatizing, they're quasi-criminal. A fraud resulting fines in more than the payment of money. It's life-altering. And in my submission, it was unfair to Mr. Cherniak in this case to have to respond to such serious allegations on only a paper record, especially in advance of discoveries at such an early stage. So in my submission, when the Court starts from the proposition that the system is now reordered, summary judgment is the norm in all cases where it can be had, and there is only a small number of cases, put your arms around them, where a trial is required. When you look at the factors of this case, regardless of what the factors this Court concludes should be considered in determining whether the interests of justice require a trial, whether it's the full appreciation test or whether additional factors should be considered as urged by the interveners, given what was at stake, given the fraud, given the character of the evidence and the issues raised, a trial is required here. In my submission, we know there's a line, and you don't have to know where to put the line to know these cases are on the trial side of it. The third issue I want to briefly address in my remaining time was the failure to apply the law to Mr. Cherniak. So the Court of Appeal set a test, and the Court of Appeal found that undoubtedly this case fails the test. Undoubtedly, if the motions judge had had this test, he would have sent the matter to trial. And then it found, as we looked at earlier, that it was not going to apply the law to Mr. Cherniak. It was going to do something else with respect to Mr. Cherniak, different than the new law that it had just announced. I submit Canadian courts should not suspend the application of a new private law principle to deny a litigant the benefit of the law established in their own case. In this case, this is particularly so for 4 reasons. 1, the plaintiffs did not rely on prior settled law. Detrimental reliance is the hallmark of, in jurisdictions where the courts say never, what they say is, well, look to see if there's detrimental reliance. That will be a governing factor. But before this appeal, the law was unsettled and emanated entirely from lower courts. Moreover, this is a procedural rule which did not factor into the plaintiff's investments decision. In fact, if this summary judgment motion had been argued under the old rule when it was intended to be argued, it was set down for March of 2009, it would have failed. The motions judge and the Court of Appeal said it would have failed under the old test, so there could be no detrimental reliance. Second, the selective approach is arbitrary and unfair. The Court of Appeal applied the full appreciation test to the 3 other cases before it alongside Mr. Cherniak's cases, and to all other cases in which summary judgment had been granted or denied before it announced the full appreciation test. Precious metals was such a case, at a time when the law was unsettled. Only Mr. Cherniak, a litigant in the very case in which the test was announced, was denied the benefit of the law. And as recognized by this Court in Hausen, again, the principle of universality requires the same legal rules to be applied in similar situations. Ensuring the universal application of legal principles, in fact, is the primary role of appellate courts. Here, number 3, here, the issue is not a constitutional one, as in Hislop, or even judge-made law. It's the application of a regulation. The Court went beyond the limits of judicial power by declining to apply the meaning of valid legislation. And finally, 4, the Court's exercise of the fact-finding powers was by its own reasoning contrary to the interests of justice. Once the Court made the determination that it was not in the interest of justice to use the fact-finding powers on the motion, in my submission, justice could never be served by making findings of credibility on the record available in order to determine if there were genuine issues requiring a trial. Because by definition, in the application of the test, the record here and the process here were not fit for that purpose. In conclusion, Mr. Herniak respectfully requests that the Malden appeal be allowed, summary judgment set aside, and that the Bruno appeal be dismissed. Thank you.
Mr. Heydary.
Good morning, Chief Justice and Justices. Hearing your questions of my colleague, my friend, Ms. Batner, I was reassured of a crucial factor that I think is key in this case, and that's that culture shift. I think Justice Abella used the word, this romantic notion of a trial. What the amended rules were meant to do is to shift our culture. I think that's the term the AG's office uses. I believe Justice Cromwell focused on the practicality of the case. What is the context? What was the outcome? Process is not our obsession here. We're in the justice business. So with that introduction, I would like to proceed this morning, subject to your questions, with setting out some background, crucial background facts, because context is everything. I do have sympathy for this court, appellate court, highest appellate court in the land, to have to deal with facts, to have to revisit matters that go back years. But we have no choice, because to give meaning to the revisions that were made to the rule, we must consider context. And context has no meaning if we don't consider the facts of each case. To begin with, I would ask two questions, the who and the what. Who's the person who brings us here? We have to keep sight of that. Who is Mr. Herniak? When we look at Justice Grace's finding, Justice Grace went through 4 days of hearing, 28 volumes of evidence. Mr. Herniak was supposed to put his best foot forward. You lead by Trump. That's, even in the old system, that was our rule. Nothing changed. This is what Justice Grace had to say. Mr. Herniak was a master of illusion. At least for today, he's dodging and weaving stops here. That was said in 2010. And here we are 3 years later. Also, let us not forget one thing. The Court of Appeal, regardless of its decision on Bruno, he came to the conclusion, and he agreed with the motions just, Mr. Herniak was involved in a fraudulent scheme from the get-go. This was not some investment that went wrong. This was a fraudulent scheme from the setup. The Court of Appeal didn't interfere with that. That would be my first preliminary point. The second would be Rule 20. I would say it comes down to access to justice. That's why I was reassured hearing the questions being asked. We're all here for a just outcome, very abstract. I think it was pointed out by one of you justices. But when we bring it down one level, what does just outcome mean? Issues such as access to justice come in. I propose to you a slightly different than the approach that's been taken to date. I've heard many members of the bench talk about efficiency, cost of litigation. If they were standalone issues, I submit to you we're in the justice business. They're crucial, because a lot of times there'll be barriers to obtaining a just outcome. The government can worry about those factors as a standalone factors. To us, they're relevant because they become material barriers to gaining a just outcome. That is our focus today. I am going to spend very little time on taking you through what were the objectives of the revisions. I think the Court is very clear on that. It was a more expeditious, but let's not forget, expeditious, efficient as it relates to justice. We're not in the efficiency business.
I wonder, though, if one of the factors that was on the mind of the Court of Appeal is really what was gained by submitting this case to summary judgment. As the Court of Appeal points out, it was a 3-year slog. You presented a bill of costs of $1.7 million, and there's going to be a trial against the other defendants anyway. So is this case really the poster boy for access to justice?
I would say, Justice Cromwell, yes. Let me give you some facts of that case. In 2010, Justice Grace ordered that there be a trial against Castles Park with dispatch. 3 years later, they brought extensive motions. Yet again, I think this was the third one, security for cost motions. There is a related third case, the Demesi case. It hasn't even come out of pleadings after 6 years. This is a unique case. There are over 60 endorsements, and this is a case-managed case. There's been the same master from the onset that managed this case. In our desperation, we approached the Associate Chief Justice in Ontario to ask for a judge to be assigned to this case, because we were stuck at times. We have a master who's case managing the case, but at certain points we have to go to a judge. Is it unique in that way? It is, but it would be the poster child for these rules. If it took $1.7 million to get this matter to a motion for summary judgment, you have to look at who created that record. Plaintiffs were examined across the board when they had nothing to say. In the Malding group, the only 2 key people who met with the relevant parties. So the practical aspect of this, to say that the plaintiffs were responsible or somehow they had a desire to prolong this increased cost, but it would be logical, Justice Cromwell, to say the defendants have nothing to gain from this matter getting to a hearing on its merit. Let's be very clear on that. On the second issue of why we're here, it is access to justice, and I would leave it at that. I would adopt a lot of statements that were made earlier in this court, this abandoning this notion, romantic notion of a trial. I think that the phrase I use in my submissions is a motion for summary judgment isn't a poor man or woman's alternative to a trial. It is an alternative, period. At times, it would be unjust, regardless of the party's resources or the court resources, to send a matter to a full trial. Those would be my comments as to the why we're here. There are 5 issues before you today that we need to deal with. The most important one is what we've discussed thus far. What are we to do with the new rules? How are we to approach them? Was the Court of Appeal correct? That's issue number 1. We've made inroads in dealing with that already. Second issue, we're proposing to you to take a contextual justice approach. Context is key. We've reviewed some of the decisions from this court. It's coming up everywhere. When we talk about efficiency, what is efficient depends on the context of the case. So a contextual justice approach is the second issue I'd like to talk to you about. Elements of the civil tort of fraud, and let's not lose sight of that. This is not a criminal proceeding. This is a civil case with accusation of fraud. And if you just look at the factual findings, I would submit you would agree with me it was a very reasonable allegation, to say the least. The fourth issue is the standard of proof in civil cases. I don't have much to say that, but I think it's worth mentioning to discourage lower courts from using loaded phrases, I would say, such as compelling. This court has dealt with cases where allegations are serious, sexual assault, fraud. My submission to you would be the one standard. It's perfect. We should discourage courts from using phrases, especially provincial appellate courts, where judges might be misdirected. We have to trust our judges on that issue. A judge sitting in bench in any Canadian province will have the foresight the clarity of mind to give the care that a case requires. It goes without saying. We don't need to change the law on that. And on the issue of a prospective overruling, I have a few submissions on that, but I can boil them down. It's a non-starter. There was no prospective overruling here. And if there was, I can deal with that right off the bat. You can make the distinction between rules versus substantive law. Second issue, you can say the court has the right to do it, so I'm not going to spend a lot of time on that. Let me lay down some of the key facts. And the reason I'm doing that is to establish context. How can I ask you to follow on a theoretical level, a contextual justice approach, when you don't have some of these?
Could you explain exactly what you mean by context?
Context, Chief Justice, has to do, we use these abstract terms. I think one of the justices talked about, we use this word just for whatever we want it to mean. To give meanings to some of these abstract notions, we need to look at the specific facts of the case. Mm-hmm. Otherwise, they're meaningless. We just get up, say...
Are you suggesting that in approaching Rule 20, it should be based on a case-by-case evaluation of the factors as opposed to, for example, categories or general principles?
Absolutely, Chief Justice.
But isn't there a tension here, and I assume you're going to address it, because it's fine to say we should have a contextual approach based on the facts of a particular case. Each judge should look at the application, decide what will be fine. But whether it needs to go to trial or not. But surely there is a place for guidance to be given as to what kind of cases are appropriate, generally speaking, criteria, maybe factors, maybe categories. I'm not endorsing any of this, but what the Court of Appeal is trying to do is say these are the general guidelines which can help judges who are faced with this. So the suggestion is maybe there's a balance. Maybe you have to look at the individual facts of the case, but maybe there's a place as well for some generalization.
Absolutely there is. It depends, Chief Justice, where you start from. The problem, what happened with the Court of Appeal decision, they started with the class system. Then, to be fair to them, we have to keep in mind, they did state you have to look at each case on a case-by-case basis, but it was too late, Chief Justice. When you start from a proposition where you set out classes, then to end it by a footnote saying, but let's look at each case. My proposal to you to reverse that order, to state by saying the new rules are meant for cases to be dealt with on a case-by-case basis. Once everybody is clear on that, and the court might want to elaborate on why that is important, to say, now here are some guidelines. There's nothing wrong with those guidelines. But appellate courts have to be mindful that their statements are taken very seriously by everyone involved. And whether it's lower court judges, members of the bar, they're all looking for that bright line. You know, the Court of Appeal said this, now we have a class. That doesn't fit in there. Now, on the issue of the Court of Appeal decision, I'd like to highlight two difficulties I've had with it. I was involved in the case. They laid on this full appreciation test. We're told the motion judge must have full appreciation of the case. But in other places, we're told the new rules, the new powers cannot be utilized unless the judge has full appreciation. Now, I'll demonstrate to you what my difficulty with that approach is. It's akin to telling somebody you need to know what's in a dark room. You need to fully appreciate what's in the dark room before you can turn out a flashlight. I just can't follow the logic. The new powers were put in place so that the motion judge could have full appreciation. To put them in as a barrier to full appreciation, I wish I could justify the logic. I cannot. That's one issue. The second issue is, my friend cited the case of precious metals. That's an interesting case, actually. One of the defendants is a co-defendant, Mr. Peoples, in this case. And identical case to us, huge volume of record, court went the other direction. The only way we can justify that to defend the court's decision to say maybe they looked at the context. Then maybe they were following a contextual approach.
Well, maybe what you're saying is that you can have guidelines, but they're not strictures, they're not absolute rules. Is that what you're saying?
Justice Rothstein, exactly. I think, but we need to.
So if that's true, then is there anything wrong generally, just very generally, with the Court of Appeals saying, well, where you've got multiple findings of fact, conflicting evidence, multiple witnesses, you might look at those things to see whether the case is amenable to summary judgment or not. Where it's documentary, few contentious issues and so on, maybe it's more likely, but don't treat those as absolute rules. Just treat those as indications one way or the other. But then, as you say, look at the context and see what you should do.
Absolutely. And as I said, I think the problem arose from we started with these categories. Then after that process was finished, the Court of Appeals said, oh, by the way, that case-by-case approach is important. And I think any direction coming from that court, I would encourage the court to start from the case-by-case proposition, to lay that understanding clearly out and say, now we have some guidelines for you. And the guideline you mentioned is something, that's absolutely, there's nothing wrong with that. But again, we go back to the issue of the new culture, the new regime. These rules were meant to give the motion judge That's a judge hearing this. When you sit through a 4-day hearing of the nature we sat with this, you have extensive finding. In our particular case, there was an expert report from the world's leading authority on prime bank fraud. Justice Gray said, I don't need this. He rejected it. It was simple. It was clear on his face. He could have called viva voce evidence. He said, I don't need this. I've got affidavits from Mr. His explanations make no sense. He's claiming I used $450,000 of the Bruno money for corporate purposes. And let's remember, he has to put his best foot forward. What happened to the other $550,000? This is his own evidence. Is he telling us now that he would put in new evidence if we go to trial? What happened to the other $550,000, Mr. Enya? They went to cover the law firm's trust account? Do I need to make any? This is his own testimony. It's in the transcript. If Justice Grace came to the conclusion he did, he had ample grounds for it.
Does any of this turn on the expectations of the parties about the form in which the information comes to the judge? I mean, when you talk about 28 boxes and lots of affidavits, what's your view about whether or not that format is necessary in order to give a judge a sense, enough of a sense of what the case is about that he or she can decide whether it needs a trial?
Justice Abella, my sense would be you err on the side of caution. You take the best foot forward obligation seriously. So you try to put as complete a record as you can before the motion judge. And as it was pointed out, you assist the motion judge to shift through this evidence. Out of the 28 boxes, most times the motion judge will come to say 4 documents, that's all I need. But if you don't have the 28 boxes, they're going to be left with the nagging dots. Did I have the full record in front of me? And that's what the rules are meant to do.
That's exactly the point. Do they need the full record, or do they need enough of the record to be able to make an assessment? In other words, what does best foot forward mean? Does it mean everything your foot has ever touched, or does it mean essentially what the core of the case is about and let the judge ask questions based on what they've got in front of them?
In an ideal world, I would say the relevant, important material. In a practical way, the way litigation in Ontario at least unfolds, it'll come down to the counsel's litigation strategy. So I'm giving you what I perceive to be a very honest answer. Should it be just the relevant material for that motion? Absolutely. But does that happen in real life? I wish I could tell you yes, but I don't believe so. Going back to a few last couple of crucial factual points. Not losing sight of the fact there was no trading program, the fact money came in. Mr. Henyak in both cases issued directions about how it was to be spent, and he received the benefit in one of them, 100% one of them, it might be 50%, it might not. Now, as a matter of law, I would put you, there is no legal requirement that says a person who sets up a fraud benefit from the whole amount, especially in the factual details of this case. I'll use that point to deal with the elements of a civil case for fraud. The tort of deceit or fraudulent misrepresentation requires the following: false statement, knowledge of falsehood or reckless disregard, intent to deceive, reliance by the plaintiff. And this is a key point. The reason I'm taking through a list you already know, it's this key point, reliance. My submission to you is when you have reliance, inducement should be assumed is submerged in there. If you don't have reliance, inducement is a factor. So that's my key point on that. I can point you to the relevant case law, but I think, you know, what I've said about it covers the area. Moving on to...
Could I just stop you there for a moment?
Yes.
This is not a convenient time. Just tell me and we'll come back to it. But
Absolutely, Justice
the
Cromwell.
question concerns the elements of fraud.
Yes.
And there are two questions. First question, I think you acknowledge that one element of civil fraud, whether you call it deceit or fraudulent misrepresentation, is a false statement.
Yes.
Is there any place in Justice Grace's reasons where he recognizes that fact?
That I would assume you're referring to the Maldine case?
In either case. When he said, as I read it, when Justice Grace sets out his description of what is fraud, he gives a quotation from a book on fraud and mistake.
I will get the reference.
Doesn't set out the elements of the cause of action.
I will get the reference for you, Justice Cromwell, but if memory serves me well, he does state there was no trading program to begin with. That's why our problem is a bit different. He makes that finding. There's no trading program to begin with. If there was a trading program, then we would have to get into the details. Was Mr. Bruno told this about this trading program? What were the Maldines told? So the starting point is Mr. Henyak sets up a fraudulent scheme. He knows it to be a fraud from the get-go. So anything he does, the assumption, I think, for Justice Grace, Justice Cromwell, was that any statements or actions by Mr. Henyak after he sets up that fraudulent scheme is a false statement.
Right. And then that brings me to the next point. In the Bruno action, can you direct me to where the judge finds that Mr. Henyak made a false statement to Bruno?
I will look for that. My colleagues will, but two crucial points I want to flag. We are relying on the Armstrong decision on the issue of agency within a civil fraud case. And what that case stands for is very clear. Civil fraud can be committed through an agent even if the agent is unaware of the fraudulent. And this is a key distinction, because at this stage, we don't know whether Mr. Peoples was a party to this fraud, he was just a dupe.
Assuming that you're correct, that the statement can be made either personally or by someone acting on your behalf, where did Justice Grace find that such a statement had been made in the Bruno action?
I will look for that by my initial response.
The Court of Appeal couldn't find it.
No, my initial response
I can't
to you
find
is,
it.
No, the initial response is the nature, the facts, the context of this case. You cannot be said to set up a fraudulent scheme, then there be a legal requirement that you make a statement to the effect Oh, actually, I might be able to give you a few practical examples. Documents were signed. All the tropos, frontline, all the paperwork signed by Mr. Heniak purported to that this whole thing was a legitimate investment. There's extensive finding on that issue. Your point is a valid one. What I'm trying to get at, I think I can at least speak with confidence for the motion. Just for him, it was a no-brainer. He was there. He sets up the fraudulent scheme. He purports for it to be a legitimate one, and he actually signs documents to that effect. These were documents that were filed by himself. There's no doubt as to their validity or credibility.
I'm not sure that I'm following. Could I ask you just very quickly to look at paragraph 157 of the Court of Appeal, where they set out what they perceive to be the law of civil fraud? If you have that.
157, Justice Hudson?
Yeah.
Yes.
So, Hriniak knowingly made a false statement to Fred Malden with the intent to deceive him. The false statement induced Malden Group to invest with Hriniak, and as a result of investing with Hriniak, the Malden Group suffered a loss. Now, I just want to understand, do you say that that is a correct statement or incorrect statement of the law? And if it's incorrect, what's wrong with it, and what authority do you have?
It's correct insofar as it's a general statement on the law. I think the one I gave is a more detailed one. For example, knowledge of falsehood, where you reckless. That's one point, finer point on it. Second point is the point raised by Justice Cromwell, that did the motions judge or the Court of Appeal ever put its mind to where was the actual misrepresentation? So, to answer your question, I would say it's a general correct statement subject to the qualifications I put in, such as on reliance. When there is reliance, a big issue was made of inducement.
Well, but just a minute. Reliance, in order to rely, you need an inducement, don't you?
With all due respect, just starting, I would say once you have reliance, you can assume there was inducement. And I can refer you to authority, I believe is tab 90. Definition of reliance is the material we filed, and it does make a statement, and I'll get you the reference in that. I think it is tab 90 of our material, which basically, in short, it states once you have reliance, you can assume there was inducement.
But inducement by whom? I mean, isn't one of the issues in this case that maybe the inducement was by somebody other than Hriniak?
And that brings me to crucial factual points in this case. Let's go back. Meeting is held in the Bruno, just to refresh the Justice's memory. A meeting is held in the offices of Castle Brock with Mr. Peoples, Mr. Cranston. Mr. Heniak isn't there. Okay? These are the crucial points in this case. Mr. Heniak gets a bill from the law firm for that very meeting. He pays it. Let's go further. It doesn't stop there. Mr. Peoples was his long-term lawyer who'd been involved in numerous similar meetings to pitch this investment. It gets even worse, Justice Rothstein.
But is the point that these people were acting as agents for Mr.
Absolutely.
Okay. People seemed to be of the view at the time, or in their reasons, that they were looking for a statement by Mr. Hriniak, and they weren't exactly satisfied about the agency proposition and so forth.
Do I agree with the Court of Appeal? I don't, because it even gets worse. Let's follow the money.
No,
who gets them?
But before you do that, I just want to make sure that I'm understanding the principle. You seem to be relying on the fact that if there is reliance, you don't, or inducement is implicit, but I'm still struggling with the connection because the inducement may come from somebody else. I guess that's where I'm having difficulty with your argument. It seems that the law is that there needs to be inducement, and I thought that the inducement had to be by the person who was intending to deceive.
I am looking for the reference for the material we filed where it exactly says what I've said, that reliance does encompass inducement. Again, I would take it a step further. Let's look at the context of this case. We can't have these debates in the abstract. And I think that's where we get into problems. Where we engage in these debates without taking the particular facts of this case. And here we are at the pilot level trying to go back, the point I made earlier. The key is when the Court of Appeal, to highlight the problem I have with the Court of Appeal, we get two very different results in two sister cases that were heard by the same motion judge, same evidence was presented. Can I explain it to you? I cannot. On the elements of civil fraud, other than focusing on the agency and the reliance inducement issue, I don't believe I have anything more to say. I would like to use a few minutes to deal with this concept we put before you. What is contextual justice? What are the practical tips? Let's start with the proposition that was stated in the court earlier. Should there be guidelines? Absolutely. Should the court consider that, to set up a procedure, test, formula? Might be the case. If that's the approach the court deems appropriate, we submit there is an easy three-stage process that could be engaged for the test we're proposing to replace the full appreciation test. Number one, looking at the context. To look at the context of the case, the court must consider the evidence. This obligation to consider the evidence comes straight out of the rule. The new rule says the judge, motion judge, or master, if he's the master, shall consider the evidence. Second stage, establishing the connections. What is context? Another abstract term. But once you take it a level down, you look at the connections that make for that context. Looking at the connections that construct that context. And this is the point that the new enhanced powers come in. Should the motion judge use the new powers? We know the test. It says, they may use it unless it's in the interest of justice not to do so. My submission to you would be, once they take a careful review of the connections, then yes, those powers should be used, again, following the rule, unless it be in the interest of justice for those powers not to be used. The final stage in the test we're proposing to you is disposition and taking action. We've gone through the context stage, we've identified the connection, we've determined whether the new powers should be used or not. The court needs to engage. And that's an important cultural shift. The old mentality would have been to look for ways that it was a cultural mindset. We were looking for ways of not engaging. There's an issue you're requiring trial, you step aside. I would say the mindset, the culture shift should be to one of engagement. We will engage, we will dispose of it unless it would not be in the interest of justice, for example, to use the powers, or there are certain matters that are appropriate for trial. There's no two ways about it. Keeping in mind what was said in this court earlier, a motion for summary judgment, it's not some cheap, some less desirable process than a trial. And that's going to be the biggest challenge for this court, to change the mindset of the judiciary and members of the bar that approach this as the same process we went through when we dealt with ADR going back 20, 30 years ago. There was a culture shift that people recognized ADR is valuable in the dispute resolution process. At this point, I'd like to deal with prospective overruling. As I stated at the beginning, there was no prospective overruling. Even if there was, just on the possibility this court sees some merit to that argument, I would make the distinction between rules and substantial law. And the third point I would raise is the point that this court has used the metaphor living tree for the Constitution. I would say the same metaphor would apply to the rules of civil procedure. More so, most practicing lawyers, we get a new rule book every year. That's how fast that tree grows. Courts constantly are faced with the situation they have to interpret them, develop them, and take them where they need to go. So those would be my questions on prospective overruling. I am going to take a few minutes to give you a few more facts of this case. I think they're relevant. For the simple fact, again, we have to go back to the context.
I'm sorry, if you're leaving, are you finished with prospective overruling?
Yes, I am, Justice.
Could I just ask you, you say there was none, and yet the Court of Appeal expressly says that in paragraph 152, we therefore conclude that going forward, cases such as the Malden group action and the Bruno action require a trial. They should not be decided by summary judgment, and yet the Court of Appeal decides it by summary judgment. Isn't that essentially prospective overruling?
I would say
apply to everything in the future, but not to this case, and are they legislating when they do that?
I would say it depends how you interpret the Court of Appeal decision. We've had two arguments here. Are we to take the Court's decision on establishing guidelines, classes? Then maybe, yes, you're right. Maybe that's prospective ruling. But of the argument I've heard, no, the Court really put those as the guidelines and came to say it's a case-by-case basis. And if we take the latter approach, there is no prospective overruling. So when I state there is no prospective overruling, I'm going on the assumption that we've accepted the interpretation that the Court of Appeal decided at the end of the day matters had to be decided on a case-by-case basis, and its categories were merely guidelines. If this Court comes to the conclusion they were not guidelines, they were classes, yes, we have a problem.
Can I just ask you one question? I don't want to take you off your track. I keep coming back to the question of what is before a motions judge and what did the legislature intend when they enacted this to overrule Aguni and Ungerman. When I look at what is required on a motion, it talks about a factum consisting of a concise argument stating the facts and law relied on by the party. How does that get into 28 boxes?
Concise. Let me answer that, Justice Bella, through using one of the more recent Court of Appeal decisions, the precious metal decision that we refer to. Same situation. Volume and volume of material. The point I'm trying to get at, just because the volume of the record is large doesn't mean the issues haven't been narrowed, haven't been put before the court in the most efficient manner possible. I see your concern, but
it wasn't a criticism, sir. It was more a question of whether part of the problem in dealing with summary judgments and the fact that they have become so out of control and in some ways not the alternative to trials. I'm just wondering whether one of the things we shouldn't be looking at is what was meant to be happening on a summary judgment motion. You've got a request from the legislature that the parties provide you come to the Supreme Court of Canada and you've got a factum of 40 pages and the arguments are made. So I'm just wondering whether one of the things we shouldn't be thinking about is the extent to which the parties feel obliged to provide every shred of information rather than following what was intended, namely give us the case, tell us a summary of what the facts and the evidence are, and we'll decide whether on this factum we can either decide the case or it can go on to trial. We just seem to have moved, as you say, this has been many, many years, much money, and I'm just not sure that that's in character of the spirit that was intended here.
I think I appreciate your question better now, Justice Abella. I have to distinguish between the material that's filed with the court in Ontario. We're subject to our own limitations. Nobody ends up filing endless amount of material. But on a motion for summary judgment at times, such as our case, extensive material relating to the evidence is put before the court. And I don't seem to be having much problem with that because we are telling a potential defendant, the respondent in the case, you will not get a trial. If we are going, we've taken the approach that, you know what, we shouldn't be so big on trial, but on the same hand, they have their role, there has to be a balance, there has to be some security for the respondent in that. You have to lead by Trump. And I'm using phrases coming out of our existing case law. In those cases, you need to err on the side of caution and file the most complete record you can. But it goes back to what the new rule says, that counsel shall assist the motion judge in shifting through this.
Can I ask you this? Because it's not too long ago that I remember having those boxes and boxes on summary judgment motions. Could the volume and nature of the record be dealt with on a motion for directions under Rule 1.05, and would it make particular sense that that be the judge who seized of the summary judgment motion? Is that one way of dealing with this issue?
That's music, Justice Karakandis, to my ears. And if this court could mandate those changes, we've got the AG's office, hopefully they're taking notes. Those are practical approaches, and they're needed whether they come through new regulation, legislation. They make absolute sense. Another point that was mentioned in this court, having the motion judge be involved in somehow, whether he or she seizes herself or being involved with the process afterwards.
Well, let me just make another suggestion. I'm just trying to look at the rules and see if there is a mechanism in the rules to make, to improve the access to justice concerns. In addition to the motion for directions, when you're looking at the reasonableness of the action for the purposes of costs, would the failure to bring a motion for directions to help deal with a voluminous record be an appropriate consideration in determining costs, reasonable behavior, and therefore costs?
Absolutely. What I understand from your comments, there's certain powers that are already in the rules. We need to utilize them more, sort of direct our minds to them. There might be new provisions that need to be added. But what I'm hearing from the court is a practical approach. And again, it goes back to a just outcome argument. I'm not standing here and, again, stating we're in the efficiency business. That's the approach I would fully endorse. And if this court could issue any guidelines to that regard, we would be very supportive of it. What I would like to do is give you my concluding remarks. A lot of what I had to say on Rule 20, it's been covered, and I don't feel the need to go over it because the mindset I see from the court is one which the plaintiffs in this case very much endorsed. On those general issues, I would just highlight two things: practicality and the just outcome. Beyond that, I don't think I could add anything. If I have any remaining time, if the court will indulge me to use my reply, I would appreciate that. I'm only going to need a few minutes to make my concluding remarks. In closing remarks, I ask that the court keep in mind the following key points. The Court of Appeals formulation of the full appreciation test under Rule 20 is contrary to the purpose and policy behind the amendments to Rule 20, which was to increase access to justice and to provide the motion judge with increased powers to resolve cases and determine when there is no issue requiring a trial. You summarize that: access to justice, new powers, new culture. The Court of Appeal further incorrectly stated the elements and standard of proof for the tort of civil fraud in the Bruno case and ignored the motion judge's finding of clear, cogent evidence of Herniak's fraud. That's a question the court has to ask. Did the motion judge make findings that were clear and cogent? There is no genuine issue requiring a trial with respect to Mr. Herniak's liability in the Bruno matter, and to force these plaintiffs to now proceed to trial when there is clear and cogent evidence establishing Herniak's fraud would run contrary to the purpose and policy behind the amendments to Rule 20. Last but not least, I will conclude by going back to the 2 points I started with, the who and why question. Who brought us here? Who is Mr. Herniak? Let's use a different finding, this time from the Court of Appeal. And this is what the Court of Appeal had to say about Mr. Herniak. Having reviewed the extensive evidentiary record, we conclude that it firmly supports the motion judge's determination that Mr. Herniak committed the tort of civil fraud against the Malding Group. Herniak's defense to this action simply has no credibility. We can't lose sight of these facts. We can't make law in the abstract. This is all about context. With the above finding in mind, and considering Justice Grace's lengthy decision and his findings about the fraud committed by Mr. Herniak, I confidently put to this Court that should this Court overturn the Maldin decision on some narrow technicality, such as prospective overruling, or not grant us relief in the Bruno decision, it will not only be a dark day for the administration of justice, but a result that will shock the average Canadian citizen due to the simple fact that Mr. Herniak will go down in Canadian history as the only fraudster who not only was able to use the legal system to commit his fraud. Let's remember, he used the good name of a leading Bay Street law firm, door boardrooms, the facts of this case. He used the legal system to commit his fraud, but was also able to utilize the system of justice to walk away from the civil consequences. Not only such results would be unacceptable in the context of this case, it would bring disrepute to the administration of justice in Canada. I can assure this Court those are not hollow statements by me. My level of concern in this case is so high. I've made this statement and I'll make it in open court. I've undertaken to my clients, if I feel they did not obtain justice, I will hang my own rope. It might be a good thing considering the experience you've had with me, I'll put that to you, but I'm sure this Court, like every court, has counsel standing before it, hearing these abstract notions, strong statements, the real people here who've been through a lot for the past 10 years. And that's what I would encourage the Court to keep an eye on. Those are my submissions, subject to any questions.
Thank you very much. The Court will rise for its morning recess.
On this matter is that the Court of Appeal unnecessarily and contrary to the wording of the new Rule 20 has restricted the use of it and thereby impeded access to justice, which was the very purpose of the rule. And I'll be making 3 points. First, what the aim of the Osborne report is, the impact of the Court of Appeals decision on Rule 20, and our submissions as to the way forward. And if I'm going over areas that you are familiar with, please feel free to stop me. The Osborne report was commissioned and subsequently implemented for the primary purpose of making the civil justice system more accessible. And there were a number of amendments proposed which were then implemented. And just to give you a context, some of the amendments that were proposed and implemented were the proportionality rule was introduced, the simplified procedure, the limit was increased to 100,000, discovery times curtailed to 7 hours, and then Rule 20 amended. And unlike what the Court of Appeals says, there wasn't one rule that was more important than others. All of the rules were important because the problem at that time with the civil justice system was viewed as it was too expensive, took too long, and was too complex for the ordinary litigant. Hence, Mr. Osborne's recommendations. Now, looking specifically at the Rule 20 amendments, as this Court well knows, the previous jurisprudence was that on a motion for summary judgment, a court could never assess credibility, weigh the evidence, or find the facts. Rule 20 specifically amends that jurisprudence. And our submission is that the problem with the historical approach to summary judgment was the notion that expedition, expense, and efficiency had to be balanced against the need for a fair process. And the new Rule 20, as drafted, by providing the motions judge with exactly those powers that he or she did not have, seeks to correct this balance. And the access to justice, the public policy purpose of the Osborne recommendations, in fact, brings together expediency, economy, and efficiency, and sees it as part of a fair process. And my submission is, when looking at the new codification, one should look at 2004, 2005, and 2006 as a package. Now, the Court of Appeal acknowledges the intent, but then in my submission goes on to rhetorically and substantively constrain the availability of this rule. And the cumulative effect of the Court of Appeal decision is to clearly state a preference for a full trial, the conventional trial process. And the Court of Appeal cautions that being knowledgeable about the content of a motion record is not the same as fully appreciating the evidence. This, although under the new rule, a motions judge can call viva voce evidence. But the Court of Appeal, in fact, constrains the ability of a motions judge to call viva voce evidence when it states that it would be better to engage in this process only after discoveries. And then the Court of Appeal proceeds to create categories, and if there are guidelines, that's one thing, but if there are hard and fast categories, that serves as a disincentive for the use of this summary judgment procedure. And the Court of Appeal proceeds to caution against using the powers of 2005. And it proceeds to introduce a new process, that of a new motion, a motion to stay or dismiss the summary judgment motion. So we have motions on top of motions. The problem for the Attorney General is that the culture shift that the Attorney General had intended to bring about by the introduction of the new Rule 2004, which codifies, it's a codification of the process for summary disposition, has been strongly discouraged by this decision. The aim of the justice system is to resolve disputes fairly and justly. A tool, a conventional tool, is the trial, but there are many others that are found in the civil justice system, such as settlement conferences, pre-trial discoveries, case conferences, and cost provisions. And in fact, when you look at the entirety of the civil justice system, you will see that all the incentives are built in to, in fact, use the trial as the last resort. Obvious example is the Rule 49 cost provisions, right? You better be very sure before embarking on a full-fledged trial. So the Court of Appeal, by tilting in favor of a full trial process, actually is not in step with the philosophy of the civil justice process. Okay, so the question then becomes, well, where to now? So I think it's important to look at what has changed under the new Rule 2004 as opposed to what existed before. In both rules, you have to find a genuine issue. But under the old rule, once you found a genuine issue, for the most part, the analysis stopped there and you were off to a trial. But here, the rule uses the words requiring a trial, and I'm not so sure that requiring a trial in and of itself is so determinative. Then it sets out the new powers of a motions judge on a summary judgment motion, weighing evidence, assessing credibility, and so on and so forth, and provides the ability of a motions judge to call viva voce evidence if he or she needs it, feels that he or she needs it. And then it provides under 2005 for the disposition of the matter in the event that motions judge using the powers of 2004 cannot finally resolve it. And in 2006, the onerous cost consequences that used to exist for a failed summary judgment motion has been removed. In my submission, this makes it extremely clear what the intention of the rule amendments were. Now, the issue is, the second issue is, what does the interest of justice mean? And my submission is, looking at the scheme as a whole, it simply cannot mean full appreciation as stated by the Court of Appeal. That is, that a motion judge decides before using the tools available under Rule 2004 whether she can have total familiarity with the evidence. This, in my submission, is limiting interest of justice to a very narrow category. My submission is the interest of justice should take into account other factors such as proportionality, affordability, efficiency, all of these factors which play a part in attaining justice.
It seems to me that the bottom line is you're proposing a highly discretionary approach to this rule.
Justice Cromwell, I would say that we are proposing a discretionary approach, and I was
certainly your test, as set out in paragraph 26 of your brief,
yes,
is very open textured, if I could use that word. I guess the concern is, though, that where there's discretion, there's uncertainty, and where there's uncertainty, there's cost.
Yes.
And that the Court of Appeal was trying to put more certainty into this so that you didn't end up on a road to nowhere.
I think that my response to that would be the Court of Appeal, in attempting to do that, any rule has jurisprudence that comes about that ripens the rule, but by its tilt towards a preference for a full trial has in fact completely taken away what the rule was intended to do. Guidelines, all rules have jurisprudence that then give body to the rules. Guidelines we have no issue with. But my submission, there is guidance already that comes from British Columbia. Now, I know the argument is in British Columbia it's a summary trial rule as opposed to a summary judgment rule. My response to that is that in Ontario, there was no need to go to a full summary trial rule because the summary judgment rule 2004, 2005, and 2006 provided all the tools to a judge, a motions judge, who wanted to then to be able to dispose of those matters which they could not. Thank you.
Good morning, Justices. You should have the condensed book of the Intervenor Canadian Bar Association. Justices, the full appreciation test is, can the full appreciation of the evidence and issues that is required to make dispositive findings be achieved by way of summary judgment, or can this full appreciation only be achieved by way of a trial? We support the conclusion that any judge needs a full appreciation of the evidence and issues to reach a just result, but in our submission, the Court of Appeal applied the test too rigidly. The test is set as a binary question. Do I or do I not have a full appreciation? If not, then on to trial. In our submission, the Court should be using the interpretive principles in Rule 1.04, that the rules shall be liberally construed to secure the just, most expeditious, and least expensive determination of every civil proceeding on its merits, and also the amendment that was included in this parcel of amendments to deal with proportionality, and that is that in applying these rules, the Court shall make orders and give directions that are proportionate to the importance and complexity of the issues and the amount involved in the proceedings. The Court needs to use the flexibility to use it as an effective building block in a proportional and efficient dispute resolution process. And in practice, what that has to include is, first of all, flexibility in dealing with oral evidence. The Court has power to hear viva voce evidence, and the Court should consider hearing that viva voce evidence if they need to get a full appreciation and to use the summary judgment so that it's proportional and efficient. And secondly, let's deal with complexity. The issue of complexity is not determinative. Motion judges have an uncanny ability to actually see the forest for the trees in motions and to understand that where there's smoke, there may not necessarily be fire. But the complexity comes clear when you look at where there's a modest amount in issue. If there's a modest amount in issue, a 6 or 8 week trial for $200,000 just doesn't seem to be proportional. But you need to craft the appropriate resolution dispute determination process so that you can get the correct answer. And as we know, even after a full trial, you're not necessarily entitled to perfect justice, but you ought to be able to apply the principles and get the just result. The third thing that one needs to consider is the ability to use the provisions of Rule 20.05 to then craft the appropriate orders, because if the Court can't, despite the paper record and despite the aid of viva voce evidence, if the motion has to be dismissed or the motion is only granted in part, then the claim must continue. And what the Court needs to do at that point is to salvage what has been used and create an appropriate dispute resolution process. Unfortunately, the Court of Appeal in combined error appeared to limit the ability to use that Rule 20.05. In particular, I'd refer you to paragraph 65, which is found at tab 5, but at the end of that paragraph, the Court of Appeal says, any trial management order flowing from a failed summary judgment motion must facilitate the conduct of a genuine trial that will permit the full appreciation of the evidence and issues required to make dispositive findings.
Can I ask you, if we were to use that rule as a way of actually fashioning an appropriate process that's proportionate to the nature of the issues involved, would that interfere then with the way a trial judge could conduct the trial? And I guess my question to you, is there any reason why the judge who's fashioned that appropriate process and put the limitations in place can't also be the trial judge?
First of all, it does have an impact on the trial, and it does fetter the discretion of the trial judge, and that may be an issue that needs to be addressed, that it's appropriate to do that because we're looking at the principles of proportionality and we're looking at efficiency in the system. But with respect to the issue of the motion judge remaining seized, Justice Brown, in the OPTEC decision, which is found at tab 6 of our condensed book of authorities, he specifically addressed that issue and thought to himself, in this case, I would like to remain seized of this because I have the familiarity with it. There may be a problem scheduling, but I think it's appropriate that I remain seized given all the information that I have. So I think that it poses a solution that I think ought to be considered. It's important to have that ability.
Would it be your thought that that would be an appropriate approach where a summary judgment judge has found one of the parties to be a liar?
You're saying in the context of granting a partial summary judgment?
In the context of staying on board as the trial judge while other claims against that person are tried?
Well, I suppose the concept, I think, would be, if you're talking about a partial summary judgment, it's more complicated. But in the normal course, Rule 20.05 would be applied when the judge has said, I am unable to get a full appreciation by what I have before me, and I haven't made any dispositive findings yet. So I don't think the judge would have tipped his or her hand at that point, but the judge will say, I want to fashion this into a dispute resolution process.
Let's take a hypothetical case with facts similar to the Bruno file.
Yes.
The summary judgment motion is dismissed, but the summary judgment motions judge made very strong findings of credibility against one of the parties, who will be a party to the upcoming trial. I guess I'm just wondering what limits there are on the ability of the summary judgment judge to stay on board.
I think there may be limits, and that's a consideration, I suppose, the appearance of justice and how that plays into the issues that we have about efficiency and proportionality.
So I thought you were addressing a situation where the judge gets into it and says, I can't do this summarily. And so the judge has not made those kind of findings. And then you're talking about the problem of how, if at all, that can segue into a real trial. And you say in that circumstance maybe it could be before the same judge?
Yes, that was.
But that would always depend. If the judge made a lot of findings, it seems pretty clear that he wouldn't be the appropriate person.
But unlikely, I would think that the judge wouldn't make a lot of findings if the judge is determined, I cannot make that decision, that he or she would say, but what I can do is, having looked at all this material, say, we really need to hear from these 4 witnesses, and we really need to have 2 experts talk, and we can do this all in 3 days, and give me your opening statements right now, or in a timely fashion, and we can get this thing done. And then I will believe that I have the full appreciation to make the dispositive findings necessary. So yes, Chief Justice, I didn't want that example, but that was the one that was given. And the other important thing is that the 2005 procedure isn't necessarily the genuine trial. It can be the appropriate dispute resolution process, and the Court of Appeals' focus on it being a genuine trial, I think, is misplaced. It doesn't take advantage of the ability to secure the just, most expeditious, and least expensive determination of the civil proceedings on the merits, and it doesn't give full credit to the amendments to the rules. And one other submission that I would make is that the judges need not be passive spectators in the courtroom. They're entitled to assert control at all stages of the litigation to ensure proportionality and to satisfy the overriding need for justice to be dispensed in a timely and cost-effective manner. Those are my submissions, if you have any questions.
May it please the Court, let me start by saying much of what we would have presented has already been presented by institutions of like mind on the subject, and I should say that the Advocate Society aligns itself with the submissions of the Ontario Bar Association and the CBA. We'd like to emphasize that this access issue under Rule 20 is about access for ordinary Canadians where high costs associated with litigation, in particular the trial process, has denied ordinary people the opportunity to have adjudication. This is not true necessarily of institutional litigants, and some institutional litigants thrive on these complex cases and complex trials. But our submission is the focus should be on ordinary citizens, number one, and number two, who are seeking adjudication. There is a tendency to say, well, there's always mediation, but mediation, as I'll come to in a moment, has another purpose and should not be relied upon to compensate for an inability to secure adjudication for those who cannot afford the high cost of trial. Obviously, the Rule 20 solution, as has been pointed out by others, is a culture shift, and it's a serious accommodation for all of us, the judiciary and the bar, to make this shift. It's very different. Certainly, those of us at the bar love the system the way it is, with elaborate trials and reports to our partners as how well we did in the third or fourth or fifth week. But the fact is, there is a very, very compelling need to fix this. And Justice Osborne's solution was, as everybody has said before me, to turn the process on its head and allow the motions judge to deal with things that theretofore had been prevented. I say with the greatest of respect, the Court of Appeal did not take up the invitation to shift the culture, because what they have said about trials makes it clear that trials, except in extraordinary circumstances, are the inescapable conclusion of the litigation process. And that, with the greatest of respect, I submit, is inconsistent with the cultural shift. Effectively, the Court of Appeal, as has again been pointed out by others, has undermined the objective of these amendments by, first of all, extolling the virtues of a trial and then identifying this abstract, generic category of cases said not to be suitable for summary judgment. And if I might just at this moment address a question you asked, Justice Rothschild, about whether guidelines, general guidelines, might be a helpful alternative. And I would say with respect, I would discourage that, because I believe the rules should operate in accordance with its terms, and to discourage or encourage its use, the cost penalty is practical. If you have guidelines or preconditions, the fact of the matter is that it's likely they will then become a basis for either electing not to grant summary judgment, or more important, as I'll come to in a moment, discouraging litigants from applying for summary judgment. And the presiding judge, if the presiding judge is looking at 20 boxes of documents to review, and there's a guideline that appears to inhibit hearing the motion, I would submit there's a risk that guidelines could become preconditions, and in my submission they are not really necessary.
So do we just say it's total discretion and just?
I would say it's a process of developing jurisprudence on a case-by-case basis, and it may be, Justice Rothstein, that down the road the jurisprudence has become a de facto guideline. But if you establish a guideline out of the gate, the implication is that it is a policy reason for not entertaining summary judgment applications. And all I'm saying is I would discourage that as an alternative. The principal step which the Court of Appeal took to undermine summary judgment was, or undermine the amendments, was to discourage oral evidence. And oral evidence is absolutely critical to these changes. The Court of Appeal has said the cases should be based on a paper record and have in effect discouraged the use of oral evidence. And without oral evidence, this rule doesn't work, because the rule will result, properly applied, in oral evidence in respect of some aspects of the case and not in respect of others. None of the conditions that have been proposed, preconditions, are found in the rule. They've been grafted upon it and opposed by the Court, and they ignore, as I've already said, the cultural shift imperative. One of the negative impacts of these preconditions is that they will discourage resort to summary judgment and thereby deny the litigant the salutary effect of Rule 2.05, which is the added process. And that is a serious difficulty because there is no other basis for finding in the rules the procedures contemplated by 20.05, and so the preconditions, if they discourage litigants from applying for summary judgment, 20.05 will be lost. By reason of the Court of Appeal dictates, Rule 20 will be undermined, and ordinary Canadians, being unable to afford the cost of a trial, will have no alternative but to accept mediation out of the system. And if a trial is ordered with a litigant that cannot afford the cost of it, that is the net result, because it's not as though by ordering a trial the shortcomings of the system are overcome. They're in fact magnified, and that is what happens. There is a mediation, and the person who is seeking adjudication is denied it by reason of an expensive trial in the offing. Or worse, the ordinary citizen may elect, as many are doing, to represent themselves. So if a trial is ordered in a particular case on the basis that the rules should not apply, either the litigant will be denied adjudication by being mediated out of the system, or undertake to represent themselves, which creates even more serious problems. I would conclude by simply saying this: I would be wary of some litigants who are supporters of the status quo, because some litigants, some plaintiffs, and sometimes defendants, utilizing the status quo, the complexity of the process, can drive the course of the litigation to the point where there is a mediated solution in their favor. So some litigants like the process because it takes them to the point where their opponent is basically exhausted by the process and succumbs to mediation. So in assessing what the proper approach is, remember, I would submit with respect that there are some who favor the process as it exists and would resist reform. Those are my submissions.
On behalf of the 1,400 members of the Ontario Trial Lawyers Association, I would like to thank the Court for allowing us to participate in these important appeals. You will have seen from our factum that we take a more cautious approach to summary judgment than our colleagues. No doubt we all share the same objective, to make our civil justice system the best that it can be, but have different perspectives on how to achieve it. As trial lawyers, familiar with the difficulties that trial judges wrestle with, even after hearing oral testimony, in deciding who to believe and sifting through complex facts, we recognize the need to be vigilant before allowing motions judges to embark on that process. 2 points are certain. First, everyone agrees there are some cases that require a trial for their resolution. The intent of the Court of Appeal was to separate the one from the other. Second, no one benefits from a failed motion for summary judgment, least of all the justice system. Even the winning party will be substantially out of pocket. The Court of Appeal recognized the need to provide guidance to judges and the profession in the form of categories of claims or features of a legal claim that lend themselves to summary determination. The Court gave further direction in the form of the full appreciation test as to what threshold should be met before a judge is satisfied to proceed with the motion and grant judgment. Our colleagues are critical of the decision, but with respect, there's nothing in their facta that would provide guidance to litigants on when a motion for summary judgment should be brought. The factum of the Attorney General amounts to an exhortation to judges to make use of their expanded powers. But that's only going to be helpful if the powers can properly be used to grant the motion. Otherwise, the hoped-for benefits from the process won't be achieved. There's nothing in the Court of Appeal decision that says the expanded powers shouldn't be exercised. The purpose of the Court was to say when they can most usefully be exercised. At paragraphs 47 to 49, the Court makes a more fundamental point by contrasting the process of decision-making between a trial and a motion for summary judgment in complex cases. The unfolding of evidence in the presence of the trial judge, the Court says, offers a greater assurance of accuracy than a fulsome review that would occur in chambers. In our view, that point is unassailable and fundamental to our conception of what justice is about: the search for truth, a fair process, and correct outcomes in individual cases. Our colleagues make the case for expanded summary judgment in savings of cost and time. In our submission, summary judgment must be looked at within the broader context of the contemporary civil litigation system. The vast majority of cases, over 95%, will settle before trial. There's mandatory mediation and pretrial settlement conferences with a judge. Case management is available if asked for. In Toronto, a specialized commercial list features judicial involvement in getting cases to trial on an expedited basis. For cases of 10 days or less, trial dates are readily available in Toronto. The argument that we need an expanded summary judgment process to deal with cases faster and cheaper must be assessed in light of all of this. Long summary judgment motions aren't fast and they aren't cheap. They don't offer a greater assurance of a correct outcome, and a successful motion might be overturned on appeal, putting the parties right back to square one.
What's a correct outcome?
A correct outcome is one that is correct based on the facts that are put before the court.
In accordance with a particular judge's opinion.
That's right.
And why do you have an assumption that you can't do that on a summary judgment?
Well, you can do that in a summary judgment. It's a matter of when is it most appropriate to do it in a summary judgment. What the Court of Appeal,
I guess it's just a question of whether you start with the proposition that what you're looking for is a correct judgment, or you start with the proposition that what you're looking for is a process that will resolve a dispute where possible between the parties.
Absolutely, where possible, and that's exactly what the Court of Appeal, I think, is getting at, because their view of the matter, I would suggest, is that if you start down the road of bringing motions for summary judgment in cases that are not going to get the result of leading to a final conclusion, then you're just overlaying the process with another costly exercise instead of going down the normal course. And one of the points that we make in our factum is that when you look at the rules for discovery versus the rules for motions, what you find is that under the rules for discovery, we now have time limits of 7 hours per party, and you're not allowed to examine non-parties or witnesses or experts. But when you've got a motion, or a motion for summary judgment specifically, it's open season. You can examine till the cows come home. And so the point that I would suggest is that summary judgment is not an efficient process in any of it.
Well, we're stuck with it. The legislature did it.
Well, they did it in appropriate cases, Chief Justice. They said it was all anchored in the interest of justice. The powers can be exercised where it's in the interest of justice to do so. And my question is, did justice change from 2009 to 2010? I think not. What they did was to give more tools to the judge to make a decision where it's appropriate to do so. And I think if you look at Justice Osborne's report in the first place, you'll see the context of these appeals is summary judgment in complex cases. Let's not lose sight of that. And it seems to me that even Justice Osborne was not anticipating that these powers would be exercised in complex cases. And he refers, for example, to the summary trial procedure and quotes that it's useful in the hands of litigators wishing to have a civil dispute of modest dimensions adjudicated in a speedy manner. So even in British Columbia, where they have the summary trial rules, which is broader than our summary judgment, it's not used in complex cases. And I think that's what the Court of Appeal is getting at. Don't use it or use it only when it's useful to do so, when there's some assurance that you'll get a final outcome.
When you, in your factum, you relied on Hercules Management and Gordon Capital.
Yes.
Which were tests that said, look to see whether or not there's a real chance of success. Where do you factor that into what you're submitting today?
Well, the actual test hasn't changed. And even Justice Osborne says that the test itself hasn't changed. It's still, is there any hope or chance of success? And Justice Osborne doesn't say anywhere that that was intended to be changed. All that was intended to be changed was the power of the motion judge to resolve disputed issues of fact. We fully accept the proposition that a motions judge has the power to resolve disputed issues of fact. In resolving those disputed issues of fact, the judge is to apply the same legal standard as has always been the case. Is there any hope or chance of success? And so, and one of the points that it comes out of Gordon Capital is that you can't just make bald allegations without supporting evidence. And that's not going to get you over the hump of creating a genuine issue for trial. That wasn't the case before, and it's certainly not the case now.
Are you comfortable with the way the Court of Appeal has set out the relationship between the chance of success and the full appreciation test?
It seems to me that the full appreciation test is an adjunct to the categories of claims. It's there as a further buffer, if you will, or you might call it a gut check for a judge to apply before they decide whether they can safely proceed and go down the road of deciding the motion. So I would conceive it in that manner.
Thank you, Chief Justice. In both the Malden and Bruno cases, the motions judge failed to identify, one, the elements of the tort of fraudulent misrepresentation, and two, to make findings required to make conclusions in respect of them. That's a clear error in any forum, at a trial or on a motion. And just to pick up on the issue of reliance and inducement, the plaintiff's decision to invest, what induced them to invest or what they relied on to invest, flip sides of the same coin, has nothing to do with Mr. Hriniak's evidence or his credibility or his trading program. It's entirely about the subjective and objective evidence as to what and when the plaintiffs decided to invest or did invest. It's about the documents they signed before they ever met Mr. Herniak. It's about their desire to hook up with a big law firm. It's about what they were looking for in terms of high-yield requirements. What induced them, what they relied on, is about them. And there were no findings made by the motions judge in that regard, and there was lots of evidence on this point. Those are errors and genuine issues which weren't resolved and which require a trial in any form or require to be resolved.
Could you tell me what you say is wrong with the approach the Court of Appeal took in paragraphs 157 to 165, which I think Justice Cromwell had pointed out earlier? What is inappropriate about the conclusions that they reached?
Okay. Yes. So, in 150, I agree they start – first of all, this is all leaving aside the prospective overruling argument. My submission, they couldn't do this. But leaving that aside, had they concluded that in spite of the hallmarks, we can have a full appreciation, so let's see what was done, they set out the correct test in 157, and then they say in one sentence, unquestionably, the Malden Group was induced to invest with Herniak because of what Herniak said to Fred Malden at the meeting at Kastelsbrock on June 19, 2001. There are no findings as to what was said. There was conflicting recollections of that meeting. Nobody concluded what was said and what induced them out of that meeting. To the contrary, the motions judge concluded at paragraph 193 of his decision, they clearly invested after, but as to why they invested or what moved them, who's to say? And specifically so since Mr. Malden's own evidence, which is at page 137 of the volume 1 of the responding record, said why I had already signed a letter of intent saying that I am interested in right now investing $1 million. That's in the record at page 157. And that's before he ever meets or speaks to Mr. Herniak.
You're saying that all of these things, because they didn't just rely on one thing. As you know, going through each of these paragraphs, it fails, it defies credibility, blah, all of those things. You're saying that represents what? Palpable and overriding error, inappropriate appreciation of the record?
What I am saying is this, at a macro level. We can have confidence that if you have the hallmarks, you're going to run into the very problems the Court of Appeal thought you were going to run into, i.e. overlooking evidence because you didn't live with it at court. And let me show you how that exactly happened in this case.
Let me be more specific. Look at 161. Even if you're right about 158, the motion judge concluded that the so-called training program was a sham, statements at a meeting, all of that.
There's no question that a motions judge always can take the evidence in front of them, make findings. But the proposition, and weigh the evidence on a balance of probabilities, you always can. The question is there something about doing it that erodes the confidence? You asked this question earlier about just outcomes. What is a just outcome? What is a correct outcome? We never can have a guarantee of a correct outcome, but we can have the confidence necessary from a fair process to arrive at a just outcome.
But my question really is just a summary motion question. If there is nothing wrong with what they did here, in the sense that they had available to them on the record the right to make these conclusions based on what the motions judge did, then aren't they saying there really is no real chance of success, and isn't that exactly what summary judgments are for? So what should be going to trial? There's no question that it's a different appreciation of credibility. But since you can do it under a summary judgment, why couldn't they hear?
Because in trying to wade through the 28 volumes plus transcripts in the back room, what happened is exactly what you would expect happened. They failed to even turn their mind to this letter of interest that was filed before. They started the story at a different point.
We don't even ask trial judges. When we review as a court of appeal, finally, we don't say you missed this piece, you missed that piece. We go to the record as a whole.
But that's because we have the confidence this Court – why? Why do we do that? When this Court explained why we do that, they said because the trial judge is in a privileged position, sees and hears the witnesses, participates in the process. That was the reason this Court gave as to why we just don't don't ask that if
So it comes down to where there is ever a question of credibility, you have to go to trial.
No,
even though the rule says you don't.
No, if the Court of Appeal had said instead, or usually it wouldn't be the Court of Appeal doing it, if the motions judges had said, in spite of the hallmarks, I can have, this is what happened in precious metal, in spite of the hallmarks, I can have a full appreciation, because this really comes down to one issue which controls. There are two witnesses who disagree, but there's this big body of evidence, documentary evidence, that is helpful in me figuring this out. Then you may well be able to, and you shall do it. But if you conclude that there's something about the quality of the record that makes it unsafe, then if you blow through that, the whole point is you're going to end up in trouble. And so when the Court of Appeal on its own, the trial judge never made a finding about inducement. So when the Court of Appeal does that and doesn't know, doesn't even start the story before that meeting, doesn't know about all the representations that were made, doesn't know about Mr. Malden's evidence, that tells us what is the problem with blowing through the characteristics and trying to figure it all out on your own, especially at first instance in the Court of Appeal in a decision where they were really trying to talk to the profession as a whole, and now they're in the minutia of inducement in this case. So if you can have a full appreciation, then absolutely you should weigh the evidence and conclude at the end of it, do I have a genuine issue requiring a trial? But their conclusions as to why, that they disbelieve Mr. Cherniak, don't even go to the question of inducement or reliance. They don't meet that issue, because the question of what induced the Malden plaintiffs, on what did they rely, it's for them to say. And if they said, we relied on Mr. Cranston, in fact, we signed a document before we ever talked to Mr. Cherniak saying we would invest, and we relied on Casselsbrock and Peoples and Imprimatur, then their own evidence is they didn't rely. And we're in the Queen and Parma case, where if there was a fraudulent statement knowingly given with the intention to induce, but it did not in fact induce, these findings need to be made to make out the tort in any forum, even at a trial. In respect of prospective overruling, one of the interveners raised the point about Rule 2.03, which says when it's in the interest of justice, you can have some flexibility. First of all, once a court concludes it's not in the interest of justice to use the expanded powers except at a trial, it can never be, in my submission, in the interest of justice to set aside that finding. Secondly, at paragraph 39 of the Court of Appeals decision, they specifically say we've got to look at this on a case-by-case basis. Only then do they go on to talk about the full appreciation test and guidelines. So that is what my friends are asking for. And they could have said, like they did in precious metal, in spite of all this, looking at this case, we do find there's a full appreciation. But they didn't. They found to the contrary. They found that any motion judge would undoubtedly send this to trial. And so in going ahead and dealing with it differently in any event, they did deny Mr. Cherniak and Mr. Cherniak alone the value of the law or the application of the law. And it matters in this case because applying the law would have changed the outcome. He would have gone to trial. One of the interveners raised the point about, well, we have to let this bubble through the system, and only then can we maybe come out with characteristics. These hallmarks were the Court of Appeals distillation from existing jurisprudence of the characteristics of cases where judges were consistently identifying that they were unsuited for summary judgment, even under the new rule. So in paragraph 61 of our factum in Bruno, we cite all the cases under the new rule where these factors, the ones the Court of Appeal turned to, were the ones that troubled trial judges. So they were not an arbitrary list of factors pulled from the air. They were pulled from the jurisprudence. Let me just end with the Osborne report on which the rules were based, just to pick up on what the last intervener addressed. Just as Osborne said, it's tab 6 of my compendium at page 35, any new Rule 20 should provide a basis for the motions judge to determine whether such an assessment can safely be made on the motion, or whether the interests of justice require the issues to be determined at a trial. At page 40, he said, it's for non-complex cases, and he said it's where there's a discrete issue requires oral evidence is when we should have oral evidence. And he said, certain cases may not be appropriate for summary trial, even broader, and a full vivat voce trial might be needed. The objective of this rule is not to eliminate trials. Any new rule should ensure access to a full trial where a case is not suitable for a trial determination.
I think we'd all agree on that.
And
Thank you.
thank you.
Reply? Mr. Heydary?
Sitting there in my chair listening to the arguments, implying, accusing different parties of not, making the culture shift, I realize I'm as guilty as anybody else. To begin with, I'd like to refer you back to the rule 2.1, the new powers. When we read that, clearly states the motion judge, subject to the test being in the interest of justice, has a lot of powers, including drawing reasonable inferences. That's our new rule. I'm counsel for the plaintiffs. I didn't even raise it. I was asked by Justice Johnston, Justice Cromwell. They're having problems with Bruno, and they're asking me to address those problems. But my answer should have been the new rule provides the platform, the basis for a motions judge to make inferences. So that's the law, that's the context. Now we switch over to address the two issues that were raised, the inducement issue, reliance issue, the Bruno issue. Justice Grace gives us an extensive decision, explicitly says, I have the powers to make these inferences. As appellate court, it's open to you to decide whether they were reasonable inferences or not. And he goes on to make extensive findings on these issues. Was there inducement? Was there reliance? Where did the money go? And related to that is, Justice Abella, your point, the difficulty you flagged with the volume of record and how does this tie in, I would tie those two issues together. It's an issue of the sufficiency of the record. The question appellate court should ask, was the record sufficient? It's not a size issue, it's not a volume issue. In a certain case, 2 volumes of material might be sufficient. On the flip side of that, was the inference reasonable? Now, I can take you through numerous passages where Justice Grace takes us a step by step through his thinking. Why am I making that inference? Why am I making that finding? The most crucial one goes to the fact there was no legitimate trading program, but Mr. Henyak presented it as such. This is a crucial. When you set out a fraudulent scheme, and you present it to the world. There's your misrepresentation, and once people sign inducement. It's very different from a contractual situation. I would distinguish it from Parna. My friend cited the case Parna. It's an excellent contrast. To refresh the court's memory, that related to purchase of an apartment building where a sophisticated apartment operator, I think that's the phrase used, bought a new building, they knew everything about that building, the contract contained a schedule with the expenses. They knew to be inaccurate. They turned around and sued the person who sold the apartment building for fraud. And that's a great contract to show you it doesn't apply in the context of this case. The motion judge had reasonable grounds to make the inferences that he did, and the new rules provide for that. Moving on to my next point. I was asked for the authority on the issue of inducement and reliance. I would refer you to tab 90 of my friend's book of authorities. On page 1171, there is an article. And I am going to refer you to the last sentence of the marked passage. In the law of misrepresentation, inducement denotes the required impact on the mind of the representee, also referred to as a reliance. Between those submissions, I would encourage you, I don't want to take the court's time. I'll be taking you through the passages in the Justice Grace's decision, but it's crucial you read those. I can give you the citations, paragraphs 168 to 171. My friend, Ms. Batten, made the statement, and the Court of Appeal seems to be saying complex cases are not suitable for motions for judgment. I would adopt Justice Abala's point on that. Nowadays, I'd like to see a simple case. The cases, the way they're litigated these days by nature, are either complex or made to be complex. So that is a practical point to take into account. Now, also the point was raised, what happens when we have a failed motion for summary judgment? Justice Karkanis raised the point, there are many tools in the process to manage what comes after. And I'd like to give you a good example of our own case. The motion judge made issued a number of orders. Examinations were to be used, transcripts. We gained a lot out of that. If this matter goes to trial against other co-defendants, much is gained. It was established this was a fraud. We're not going to spend 6 months in trial arguing the case as brought. Was this a legitimate program? Or was it? Becomes an issue, really a strict legal issue. What was the level of viability? So much is gained, even in cases such as this. But I would adopt the proposition that there has to be more involvement by the motions judge. How do we achieve that? I don't have a solution for the court. Also, the statement was that fraud is a quasi-criminal matter. I disagree. That's incorrect. This is a civil fraud. This is a civil case involving a claim of fraud. There's no quasi-criminal proceedings here. So I think that's an important point to keep in mind. In closing, what I would like to do is highlight the fact I think one of the interveners has stated there is a compelling need to fix this situation. I think that's an accurate statement. That being the case, the only assistance I can offer the court is to adopt Justice Abala's words and say we need a new map. And this new map has to chart the new culture for us, all of us. Even myself, my opening line was, I should have recited the new rule to you. I should have said the judge Justice Grace had the right to make reasonable inferences. But I didn't, because culturally maybe I haven't made the change. It won't be easy, but I'm confident the court can provide us with assistance in that regard. Those are my submissions, subject to any questions the court might have. Thank you.
Thank you very much. We thank all counsel. The court will reserve its decision on these cases, and the court stands adjourned.